Let's start out this blood alcohol content that you wanted to get this motion denied. That was a big blow.
Well, it really isn't. What it is, and I expected it, it's a motion denied at this time. They still have to lay the proper foundation at the time of trial. So they can't just come in and say, this is your test result. They have to show that they drew the blood properly, they preserved the blood properly, and they tested it properly. And if they don't do that, then it's not allowed in. At least under the law, it's not allowed in.
But correct me if I'm wrong, you wanted to have this thrown out beforehand, right?
That's well, I wanted the blood test results before trial, and the judge denied it. The judge has full discretion on rules of evidence of how it would be heard, and that's what he ruled, and that's what we live with, and we continue on.
If that was your interest, I heard the judge talking to you about potentially bringing witnesses in that you would have support the contention that you're making. Why wouldn't you, if you didn't want it in front of the jury at all, why not do that with witnesses now?
The judge is not allowing it.
Because of the filing timing, or?
I told the judge excused the filing timing, finding good cause that because of the expert that was retained and the medical records that were just received 2 weeks ago, if that, I couldn't prepare a motion. I didn't know that there was something that was in error in addition to the officer testifying as prelim. So the bottom line is the judge found good faith that I couldn't have done it at that time. The judge is allowing it at the time of trial. What do I think that does? It taints the jury. It just taints the jury. The jury aren't attorneys. The jury aren't scientists. They're not toxicologists. And it taints the jury. And given that 4 out of 5 motions have been denied, I expected this one to be denied.
But with all due respect, why do you think it taints the jury? I mean, they're going to have to listen to all the testimony, the cross-examination, all of this evidence that's going to come out during the trial.
The foundation. If the judge wants to proceed that way and have the foundation requirements come out at trial, they will hear it. If he chooses to follow my request, and that is have a separate hearing during the trial outside of the presence of the jury, meet the foundation, then bring the jury back in, and then continue the trial. And if you ask, well, what's wrong with just the jury hearing all of this? Because jurors sometimes don't have the training, the certification, or once the result is out, sometimes they'll just think that that's the result. What is this attorney trying to do something with how the foundation was? The judge allowed it in. He said the numbers. That's good enough for me. And I did ask the prosecutor. I said, are you going to bring up the .18 during the opening statement? Because that really taints before evidence is allowed. You're telling the jury things, and you're already tainting them. And he said that he will not mention the blood alcohol results during opening argument and jury voir dire, the jury pick, which I thanked him.
This other thing with the property, what does it matter if it's private property or not? I mean, you still can't drive around and, under the influence or have a seizure and run into a building and kill kids. It doesn't matter if it's private or not.
The statute specifically states that it has to be public property that you're operating a vehicle under the influence or open to the public. This property was private. It was membership only. It would be trespass if you entered it. This wasn't a Burger King or McDonald's. The statute, and we're following the statute. I'm not making up the law. Statute says that for you to be arrested for drunk driving and to be charged, it has to be public property. In other words, you're drinking and you're going up and down your driveway. That's not drunk driving. You're driving around your backyard or your field or your acreage. That's not drunk driving. When you enter the public right of way, then that's drunk driving. That's what the statute says. I didn't make it up.
But the law is you can't drink and drive.
Right, but that doesn't, you can drink and drive if it's private property. I know that's sort of tough to, and what you're really thinking is this. What you're actually, I believe, thinking, and you're sort of putting them together, is that for the 2 charges of murder too, if you're reckless and dangerous and things like that, then you can be charged with murder too. Now that's whether it's private property or not private. But if you're going to charge them with operating a motor vehicle while intoxicated causing death or causing great bodily injury, then it's got to be on public property. Because you'll look at it, and I understand where you're coming from, you're saying, wait a minute, does that allow somebody to get drunk, and if they are drunk and drive around and kill people? No, it doesn't. That's where you can charge somebody with a homicide or murder charge. But you can't charge them with driving under the influence on a public road or a public place. That's what the statute says.
And your client has to clear a blood test yet again today, correct?
A urine test, yes.
Just to make sure because of the...
Just confirm. And again, remember, it was a .01. Even a child can have a .01 because your body itself makes up alcohol. It causes it naturally.
Depending on the results there, basically it's cleared now until March the 3rd and underway we go? Or
that's
no
correct.
Other motions,
right now, the Court of Appeals, on February 14th, Valentine's Day, they issued their order that said that go ahead and go to trial and that we're not going to hear this case with regard to the adjournment. We are in the process of appealing to the Michigan Supreme Court for the adjournment because our material, our main witness, is not available right now because he's under arrest and charged with 35 counts of criminal enterprise.
And that's her doctor, right?
Dr. Garg, G-A-R-G.
And he's the one that cleared her to drive?
Oh, yeah. He said 6 months, and you go ahead. He didn't say, come back in. He says, you're good.
But
he's following doctor orders.
He's not exactly the most credible witness. No offense.
No, I agree. But there's no medical records, no nothing that says that you cannot drive beyond those 6 months. And she waited 6 months and 3 weeks. And he never
but you and I talked about this last time.
But
she had a seizure in March and went to the hospital, and she had another seizure while she was at the hospital. She was hospitalized for a total of 10 days, 6 at one hospital, 4 at the other. That was March. This happened in April.
Right. Why didn't the hospital and the doctors at the hospital say in their records and to her, do not drive, do not operate a motor vehicle?
Because they refer you to your primary care physician. This has happened to me before.
Okay, well.
And I couldn't drive for 6 months.
I understand. Also, their primary physician should have sent by law to the Secretary of State her medical condition, and they automatically, without a hearing, suspend it and then say, give us a hearing in the future when you have medical approval to drive. It wasn't done.
Thank you.
You're welcome.
Thank you.